Finally, we get to the Equal Pay Act. And the Equal Pay Act is not anything new. The Equal Pay Act was actually passed the year before Title VII in 1963. And the Equal Pay Act mandates equal pay for equal work, that men and women must receive the same pay for the same work. Yet we know that really hasn't worked. So what is the problem? Well, part of the problem is trying to understand what is equal work. And equal work under the Equal Pay Act is not actually the exact same work, but it must be substantially equivalent work. And how do we determine what is equivalent work? We look to see, does the position involve equal efforts, equal skills, and equal responsibility? So in terms of effort, we look at things like, what is the level of physical or mental exertion needed for the performance of the job? That would imply equal effort. Equal skill, you look at things like experience, training, education, ability. What level of experience is needed for this job as opposed to that job, or training, or education? So those are factors indicating equal skill. And finally, equal responsibility has to do with accountability. How much accountability does a person have for any errors or mistakes in their work that they conduct? So when a court has to determine equal work in order to answer the question of, is this person receiving equal pay, they have to look at these three factors: equal effort, equal skill, and equal responsibility. And I would encourage you to remember those three because it's an easy thing to test on, and it's an easy thing to remember. We also look sometimes at working conditions. What are the physical surroundings or hazards involved in a job? Those can indicate what is equivalent work. Now, part of the problem with the Equal Pay Act is that there are broad defenses. And a defense in the law essentially says that, look, everything you said is true, but. And the Equal Pay Act sets out certain defenses to liability, saying that if you can establish these, then in fact, you're not going to be liable. So we could pay men and women differently based on certain matters like a seniority system. Now, it has to be a bona fide system. It has to be a pre-existing system. But if our system provides for greater benefits, greater pay to people with more seniority, and those people with more seniority tend to be men, then that's a justifiable pay differential. That's an affirmative defense saying, yes, we pay women less, but we can do that because we only pay them less because of our seniority system. A merit pay system is also a defense. We treat people differently based on merit. Again, the merit pay system has to be bona fide, has to be actual. This is why we conduct employee evaluations. This is why we look at your performance and measure it and oftentimes give you a grade, because we want to protect against the claim of under the Equal Pay Act. Our merit pay system is legitimate. We pay the good performers. Productivity pay system, if it's based on productivity, how much do you do? If your pay is based on your level of productivity, then that's also a defense. And finally, this is a broad defense that can take into account a lot of things, a factor other than sex, meaning any factor other than sex could lead to a successful defense of an Equal Pay Act claim. This factor other than sex is a broad defense and allows you to assert virtually anything as the reason for the unequal pay. The best case involving the Equal Pay Act has to do with a Northwest Airlines, which had a tradition of hiring females as flight attendants, but hiring men as flight pursers. It was essentially the same job. The role of the purser was essentially 90% the same as the flight attendant. Nevertheless, pursers were paid more, in large part because they were predominantly male, and the belief system back in the 1970s was that it's okay to pay men more than women because men have to take care of the family, they have to be the breadwinners, and therefore women can always get married and not work, therefore we have to pay men more. So in this case, the court looked at the equivalent work that the male and the male pursers and the female flight attendants were doing, and decided that's an equal pay. I mean, that's liable for an Equal Pay Act violation because they were essentially doing the same job, but under two different pay scales. The EEOC enforces the Equal Pay Act. A party, however, can sue under the Equal Pay Act separately. It can be part of a Title VII claim, or it could be a separate standalone lawsuit. The remedies are not great. They include back pay and an equal amount as liquidated damages. One of the reasons we don't see a lot of Equal Pay Act litigation is the damages are not too great. They're not too large. That doesn't attract the interest of a plaintiff's lawyer. So it's very limited remedies. And in talking about limited remedies, this was a case that kind of exploded into the world 10 years ago and got a lot of attention. It involved a woman named Lily Ledbetter. And Lily Ledbetter was hired by Goodyear Tire and Rubber Company to work at their plant in Alabama. She worked on the assembly line alongside men doing the exact same job, and she was doing the same job as them. And nevertheless, she was hired at a lower amount than the men who were doing the same job under this justification that, hey, men need to earn more money because they're breadwinners. Well, the problem is Miss Ledbetter did not realize she was being paid less than her coworkers. And in fact, she worked at Goodyear up until the time of her retirement. And it was not until after she retired and started to collect her retirement pension, and she discovered that the amount that she was receiving was much less than the men who had also retired around the same time. And so she started to look into it, and she discovered that she had not been paid the same for the previous 25 years of work. And so she filed a lawsuit claiming violation of the Equal Pay Act. The problem, however, is that short statute of limitations to file a charge with the EEOC. Remember, you only have 6 months. And so what the court said, and this went all the way to the U.S. Supreme Court, and what the Supreme Court said is, look, we feel terrible about this, but the fact is that your claim arose every time that you were paid less than your coworker, and that started your 6-month clock running. And the same the next time, and the same the next, and the same the next. So by the time she filed her lawsuit, the only claim she had was based on her final paycheck, which was, of course, remarkably, a small amount of potential damages. And so Miss Ledbetter did not receive much in the way of damages, despite clear evidence that she had been paid less for doing the exact same job for a number of years. Well, this got a lot of attention, and eventually there was enough public pressure that Congress enacted the Lilly Ledbetter Fair Pay Act of 2009, which changed the statute of limitations for equal pay claims, such that all equal pay claims will now relate back to when the first unequal pay was made, and so that will preserve all that. It did not help Miss Ledbetter for her case, but it is for future cases. when it comes to Equal Pay Act claims, you no longer have that short statute of limitations. So in conclusion, what do we learn? Title VII prohibits discrimination in employment based on sex. Sex discrimination can appear in different ways, and the Equal Pay Act prohibits sex-based pay differentials between men and women as long as they are performing substantially equivalent work. And that's it. Thanks for listening.